How do I follow that? Right, so I thought I'd come and tell you about Stransham Ford, the ruling in the Supreme Court of Appeal, the good, the bad, and the ugly. And I chose that title mainly because there were positives to be taken from the decision that we are going to build on, certainly in the next case, and secondly, because I thought it was catchy. So let's start a bit with the background. So initially we had success before Justice Fabricius, and that matter was brought on an urgent basis. It was heard on the 29th of April 2015. During argument, it became quite apparent that Justice Fabricius was with us and would grant an order. Towards the end of the day, he only sought input from the other parties as to what that order should be or how it should be framed. The only party that requested a bit of time to obtain instructions was the minister. The very next morning, when we returned to court, the minister did not provide any instructions. So there would have been an order that afternoon prior to Mrs. Stransham Ford's death.
Could you explain the case?
Well, the Stransham Court case was brought on an urgent basis because Mrs. Stransham Ford had suffered from terminal cancer. He had only, at that point in time, I think when we launched the application, if memory serves, 2 weeks to live. We cited the Minister of Justice, Minister of Health, the Health Professions Council and the like as respondents in the matter. The papers, it's an application procedure, so it's not an action, it's not a trial. You don't have witnesses in the box that you cross-examine and the like. It's all done on affidavit. In our system, you can bring it on an urgent basis in certain circumstances, and it's always up to the discretion of the judge whether he deems the matter urgent or not. In this instance, that was the finding by Justice Fabricius. Coincidentally, when we launched the application, we weren't in fact aware of the Carter case in Canada. So that came about even after the papers had been prepared, and which was in fact supportive of our argument. And Justice Fabricius, of course, relied quite heavily on that decision, as well as many of the other arguments, and some of which was advanced as Kessler had put forward by us, in fact. He then found initially that you do have the right to assisted suicide by a physician. It was a great victory. Unbeknownst to us, regrettably, Mr. Stransham Ford had passed away about 2 hours prior to him handing down the order the following morning. What then resulted was that the State and the Health Professions Council sought to appeal Justice Fabricius's ruling. And they cited the estate of Stransham Ford as a respondent, who we then act for. Then let's start off with the ugly. We lost. The judgment was given 6 December 2015. It wasn't a very pleasant Christmas surprise for me. And then to the bad, some of the reasons that was put forward by Justice Wallace on behalf of the court. Justice Wallace said that Stransham Ford sought relief for himself and himself only. And that is correct. He asked that. And the reason why it was framed in that manner is that the approach that was adopted was let's rather try and work in increments as opposed to open the floodgates, which our opponents would surely argue. And also because it was brought on an urgent basis and the circumstances of his health could differ from applicant to applicant. And the judge then found that because Mr. Stransham Ford had passed away, before the order was spoken, in our law, the moment the judge speaks an order, that's when it becomes law. There was no cause of action. Therefore, the relief had become academic. The cause of action didn't exist and passed away, regrettably, with Mr. Stransham Ford at that point in time. Justice Wallace said, however, because various jurisdictions look to each other for some guidance in various matters, it was important for him to nonetheless discuss the merits of the matter so that Justice Fabricius's case isn't used as the leading South African authority. And he started with the outset to say that physician-assisted euthanasia is murder and consent is not a valid defense. The question was, should that change? If it is to change, then the previous principles laid out in previous cases, such as Grotjan and others that Kessler had referred to, has to be challenged. He said that challenge wasn't made in the court before Justice Fabricius. He said no doctors came forward to say, we want to assist patients in dying, whether active or passive. And because there were no doctors, that relief was not invoked, and it was not debated before the Court of Quo whether the law should change in that regard. Justice Wallace said that Strange and Ford, in effect, truly sought to determine the manner and the time of committing suicide, or how he could commit suicide. And in the opinion of Justice Wallace, the fact that suicide is not a crime was absolutely an irrelevant consideration. Justice Wallace then went into some discourse about causality and certain factors as to determine when a person ought to be guilty of committing a crime in assisting a patient to die. He looked to the actor and the act. The final act, of course, generally in assisted dying or with assisted suicide, is that the patient themselves would either drink some form of medication or inject themselves with some agent to cause their death. But Justice Wallace said, if the train is set in motion by a physician, that is, the physician prescribes a lethal agent for the patient to self-administer, that physician surely would foresee that the patient's ultimate goal would be achieved. Therefore, there could be a conceivable causality role, and with the knowledge and intent that the doctor prescribes it, the doctor could be complicit in murder. However, he said that whether or not it is a crime is always dependent on the facts. He extended that principle not only to physicians, but also to other third parties who help or enable a person to commit suicide. He then posed the question whether the law should be developed requires investigations into a number of difficult questions about the meaning of certain guarantees in our Bill of Rights. Does the guarantee of the right to life include a right to die, or does it stand in opposition to it and support the criminalization of physician-assisted euthanasia? Does the right to dignity extend beyond dignity in the process leading up to our inevitable death, so as to encompass a right to die when and in a manner we choose? When we are in reality concerned with the implications of the criminal law for the medical profession, do the rights of patients warrant a change in existing criminal law as it affects doctors? Does the right to health care extend to the provision and possible administration of lethal agents, or does it by necessary implication exclude this? What are the implications of palliative care for the question whether a person's dignity is infringed by the inability to terminate their own life or have it terminated? The court had regard to various foreign jurisprudence and, of course, indicated that that foreign jurisprudence, in fact, shows that the state has a legitimate interest in imposing constraints on the application of physician-assisted euthanasia, physician-assisted suicide, and other forms of aiding and abetting suicide. The facts of previous cases, such as Grotjan and others, the judge held, also indicated that South Africa's own government or state has a legitimate interest in the same regard. The court held that some constraints were plainly reasonable and justifiable in an open, democratic society based on human dignity, equality, and freedom. The question was what? And, the court required, or the next court that is required to consider the decision has to consider the nature of any right that was infringed by the present state of our law, as indicated by Kessler as well. In respect of that limitation, the importance of that limitation and the purpose thereof, the nature and extent of the limitation, and the relationship between the limitation and its purpose and less restrictive means to achieve that purpose. And for example, especially in Canada, in Carter's case, that was what was found to have been overextended. Carter held that the criminalization of aiding and abetting suicide unjustifiably infringed a protected right. In Canada, their constitution differs from ours. They, for example, do not have a right to dignity in their constitution. They've got the right to life. But in the right to life, the right to dignity is encompassed. And the court accepts that that right exists. Justice Wallace continued to say that whether a South African court faced with the same issue would arrive at the same conclusion would need to be determined in the light of very different circumstances in this country. That is, the availability of medical care, especially palliative care, the wide diversity of our society and its cultures and belief systems, our sense of the need to protect the poor, the weak, and the vulnerable, and the value attached to providing such protection. Now, I interrupt my discourse or my discussion relating to Justice Wallace's reasons just to state here that I agree with Gessa here. I mean, that cannot be a justifiable ground to consider whether the individual has a human right or not. And it cannot be suggested that other countries do not propose to protect their weak and their vulnerable. The court, Justice Wallace then continued to say that Justice Fabricius was too ready to adopt the reasoning of Carter and ignored the different context in which that case was decided. Justice Fabricius said that, or Justice Wallace said that the Court of Quo's desire to deal urgently with the matter was that resulted in an insufficient opportunity available for a fair public hearing on the matter and for determining those issues. Also didn't give our opponents an opportunity to examine Mr. Stransham Ford. And accordingly, the medical evidence before the court was sparse. We did have two doctors that verified Mr. Stransham Ford's prognosis, diagnosis, and the like. So with respect to Justice Wallace, I do not understand how it could have been. And what I found also surprising was that Mr. Stransham Ford put forward the possibilities that might arise from his condition, which he wished to avoid by electing to choose to end his own life. And Justice Wallace said, well, we don't have evidence to see whether that in fact could have been a reality. And in reality, that didn't happen for the most of it. He was only in and out of a coma the last week. With respect to the learned judge, find that a bit disturbing. And what I also find disturbing is to question the evidence in circumstances where he had died 2 hours before the order. We certainly did not fake that. So the court then continued to say that a feature of the cases in this area is that there is evidence that a medical practitioner is available and willing to assist the patient, but is only willing to do so if they are not to face criminal prosecution or possible sanctions from the medical fraternity. And that was absent from Stransham Ford's case. Now, I again interrupt myself just to point out that in our new case, we have put forward a doctor in these circumstances to deal with this criticism by the Supreme Court of Appeal. Justice Wallace then relied heavily on the judgments of Lords Mance and Sumption in the Nicholson case. And you would have heard Elena speaking yesterday so eloquently about the Nicholson case. Regrettably, we were, of course, in favor of Lady Hale and Lord Kerr's opinions in that judgment, which I think any academic will also tell you was logically sound and philosophically sound. The court then continued to say that the notion of a dignified death must be informed by a rounded view of society, not confined to a restricted section of it. This was not done and could not have been done because of the inadequacies of the evidence and haste with which the case was decided. Now, I think this emanated from part and parcel of the criticism of our opponents, which was that only the rich would be afforded the opportunity to have assisted dying. Of course, we countered those arguments in court, but it did not seem to have the desired effect, because the same would hold true, for example, for abortion. And having followed Lord Sumption and Lord Mance, Justice Wallace also thought and deemed that Parliament was the appropriate forum, preferably to decide the issue. But that brings me to the good. So hope springs eternal, or in the South African proverb, hope does not kill. I shall live in hope of getting what I seek another day. The court started out to say that welcome advances in medical science in most circumstances are welcome, but in some they can lead to the process of dying being protracted and painful and burdensome. And this acknowledgement, I think, is important because it acknowledges the problem. It acknowledges the difficulty. It doesn't speak it away. The court quoted from R versus Adams in dealing with the following, and that's the haste in which Justice Fabricius, according to Justice Wallace, made or came to his conclusion, to say that nor is it desirable for a lower court to embrace the exhilarating opportunity of anticipating a doctrine which may be in the womb of time, but whose birth is distant. But again, I see this as a positive because, well, at least we're pregnant. The court held that a person may refuse treatment that would otherwise prolong life. This is an aspect of personal autonomy that is constitutionally protected and would not ordinarily be regarded as suicide. The only qualification, of course, is that there must be both mental and legal capacity. Considerations of advance directives and living wills or similar documents or expressions of wishes left aside. However, much was to be said for the position that any such prior instruction clearly expressed should be heeded, which I think is also important because there is I've heard questions about the effect of living wills, what effect is to be given to them, and I think Justice Wallace acknowledged that they should be adhered to. Interestingly then, Justice Wallace continued to say that a doctor in South Africa does not necessarily commit a criminal offence by ceasing treatment or other forms of medical intervention that serve neither a therapeutic nor a palliative purpose. There was no offence in prescribing drugs by way of palliative treatment for pain that the doctor knows will have the effect of hastening the patient's death. That's what, as we all know, the so-called double effect. And he quoted to say that if the first purpose of medicine, the restoration of health, can no longer be achieved, there is still much for a doctor to do. He is entitled to do all that is proper and necessary to relieve pain and suffering, even if measures he takes may incidentally shorten life. He came back to the question of causality and the prescription of a medicine or an agent by a doctor that would cause death. And he then dealt with Grotjan. Give a man a gun is my part. That was not what the judge said. But that was, as Kester explained to us, with the husband that gave his wife the weapon and said, shoot yourself. There he said there was clearly an inference to be drawn that that man had intended that she should kill herself and that this was his intention in providing her with the means to do so. Although a completely independent action, what is required, in fact, to avoid prosecution in those circumstances would be a complete independent action in the sense of being separate from and unconnected to the earlier conduct, which would then break the nexus or the chain. And this is the important part. Justice Wallace then said, thus, it is a completely different situation where a person provides the means to commit suicide, but neither encourages nor performs any direct role in the act of suicide, and may in fact seek to discourage it. The court held that Grotjan, in fact, did not decide that it is a criminal offence whenever a person encourages, helps, or enables someone to commit suicide or attempts to do so. Whether they will depends on the facts of the case and the issues of intention, causality, and unlawfulness. And then profoundly, it follows that it cannot be said that in the current state of our law, physician-assisted suicide is in all circumstances unlawful. The court continued, confronted with the case of physician-assisted suicide, would have to consider how the principles articulated in Grotjan should be applied and adapted to the present day. The background, the court said, would be markedly different. Grotjan was decided almost 50 years ago, and since then, of course, we've become a constitutional democracy. And Section 39, sub 2 of the Constitution enshrines that the common law should be developed, and the courts must strive to give effect thereto and to the nature and purport and objects of our Bill of Rights. Justice Wallace found assistance from foreign jurisdictions in the approach to causality and the type of situation that could be dealt with reference to the House of Lords decision in R versus Kennedy. In that matter, it was two homeless persons who one night at a shelter of some sort, I believe, were together, and the one couldn't sleep, so the other gave him a syringe with heroin. The deceased took the syringe, injected himself, and died. Now, initially, the person who handed him the syringe, or gave him the syringe, was found guilty of manslaughter, or culpable homicide, as it is known in some jurisdictions. And the House of Lords then said that when it is appropriate to find someone guilty of manslaughter, where that person has been involved in the supply of a Class A controlled drug, which is then freely and voluntarily self-administered by the person to whom it was supplied, and the administration of the drug then causes his death. Now that is the certified question. When is it appropriate to find someone guilty under those circumstances? Court then continued to say that it is possible to imagine factual scenarios in which two people could properly be regarded as acting together to administer an injection. But nothing of the kind was the case here. As in R versus Dalby and R versus Diaz, the appellant supplied the drug to the deceased, who then had a choice, knowing the facts, whether to inject himself or not. The heroin was, as the certified question correctly recognized or recognizes self-administered, not jointly administered. The appellant did not administer the drug, nor for the reasons already given did the appellant cause the drug to be administered to or taken by the deceased. The answer to the certified question is, in the case of a fully informed and responsible adult, never. Our court then continued to say that whether and to what extent a future court would determine that physician-assisted suicide was unlawful is unforeseeable. Only at that stage would the question arise whether the criminal law involved an infringement of a right in the Bill of Rights. Assuming that a matter reached that stage where the court thought that a development of the common law was required in relation to physician-assisted suicide, it would then have to decide whether that should take the form of a different view of causation, intention, or of unlawfulness, or in fact of the possibility of a special defense for medical practitioners or carers. With reference to other jurisdictions, Justice Wallace said that in the Netherlands it evolved in the development of a defense of necessity. In Montana, in the United States, it required the development of a defense of consent on the basis that the absence of criminal intent on the part of the physician meant that their actions were not contrary to public policy. And in Colombia, it appears to involve a finding that the actions of the physicians are not unlawful. Importantly, Justice Wallace did not deal with the opinions of Lady Hale and Lord Kerr in Nicholson. He did not deal with the opinions of the Supreme Court justices in Glucksberg's case in the United States, which were in our favor. And he didn't deal with the case in Namibia of Justice O'Regan, which was also in our favor at all, without explanation. Lastly, the court dealt with the question of physician-assisted euthanasia versus suicide. And with reference to Carter Quo, where it was found that Taylor, in that case, could not commit suicide due to the condition that she was suffering from, which infringed the right to equality in the Canadian Charter, and held that the question in our law, with reference to Section 393, that distinction would also be a debatable one. And I've quoted Section 93 for you. You can read it yourself, so I won't, for the purposes of time, I'll read it to you. The court then said, when an inappropriate case comes before our courts, the common law will no doubt evolve in the light of the considerations outlined and the development in other countries. But again, emphasized that it would be preferable if Parliament would intervene. And that was Strange and Ford.